Good day, everyone. We are the Group 4, and we're going to report the Article 1817 to 1827. I'm Villarimo Annalyn, and my group mates are Salvo Eustiquio I, Tabius Rosalinda, Cerezo Kenneth, Agasita Stephanie, Katian Kenan Jaira, Siguran Yancris May. Article 1817 as stipulation eliminating liability. It states that any stipulation against the liability laid down in the preceding article shall be void except as among the partner. Article 1817 as to third person. All partners are liable pro rata and subsidiary. In liability laid down on Article 1816, contractual obligation with third person in the name of the account of the partnership under the signature and the person authorized includes all partners whether they are capital or industrial, they are still liable, pro rata and subsidiary with all their personal property. This liability takes effect after the properties of the partnership have been exhausted. Example is that if C is insolvent or if B died or if A has left the country, the liability of the partners cannot be increased. If someone asks, is it permissible to stipulate that a partner be exempt from liability? There's a general rule of that. The answer is no. Reason? All partners are liable with all their property under Article 1816 in relation to the principle of commonality of interest. But there's an exception. It could be yes, but only valid as among the partner. Article 1818 acts of a partner that bind the partnership. Second, acts of a partner that do not bind the partnership. Article 1818 acts for apparently carrying on the usual way the business of the partnership. Take note, every partner is an agent of the partnership for the purpose of its business, and the act of every partner, including the execution in the partnership name of any instrument for apparently carrying on in the usual way the business of the partnership of which he is a member binds the partnership, unless the partner so acting has, in fact, no authority to act for the partnership in the particular matter, and the person with whom he is dealing has knowledge of the fact that he has no such authority. In continuation with our Article 1818, there are two things that we should remember. There's a general rule and exemption. Okay, in Article 1818, as stated a while ago, there's a general rule of that. The act of every partner, including the execution in the partnership name of any instrument, for apparently carrying on in the usual way the business of the partnership of which he is a member binds the partnership. The keyword is binds the partnership. The exemption, he has in fact no authority to act for the partnership in the particular matter, and the person with whom he is dealing has knowledge of the fact that he has no such authority. Article 1818 Par 1. This should be read with Article 1803. There is presumption that all partners have equal in the management of the partnership and its conduct. Hence, every act of every partner which is the connection with the conduct of business of the partnership binds the partnership. But there is an exception. When partners has no authority to do so, and when the person to whom the partner mentioned above is dealing with knows that he has no authority. In Article 1818, acts of strict dominion or ownership, an act of a partner which is apparently for the carrying of business of the partnership in the usual way does not bind the partnership unless authorized by the other partner. Apparently carrying means actions which are connected with or within the scope of the usual course of business. Example, if A, B, and C are in a contract of partnership for buying and selling cars, if C is authorized only to buy cars on cash basis and he buys a car from X on the installment basis, the partnership will still be bound by the transactions because it was apparently connected with the course of business.
Good day, everyone. I am Eustiquio de Salvo, the first of the group 4. The article that I am going to discuss is the article 1819. This article tells us the effect of conveyance of partnership property depending on whose name it was conveyed. So, what is conveyance? Conveyance is a transfer of ownership or title. As you can see that the Article 1819 has a long provision. So, in order to maximize our limited time, I will not read the paragraph word by word, and I advise that you read it. I will just simplify each paragraph or the scenarios of this article. Okay, let's start. The first paragraph, the scenario is that the partnership property is in the partnership name and the conveyance is done in a partnership name, and the conveyance is done by a partner that has no authority. Under the first paragraph of the Article 1818, this conveyance passes the title, but the partnership can recover the property if the conveyance is not in the usual way of business or a fraud, or the conveyance is in the usual way of business, but the buyer has knowledge that the transact partner has no authority. And on the second paragraph, the scenario is that the partnership property is in the partnership name, and the conveyance is effected in the partner's name, and the conveyance is done by a partner that has a lack of authority. This conveyance does not pass the title, but only the equitable interest. So, what is equitable interest? It is a kind of title that is not perfect or incomplete. It may be converted to a legal title only if the buyer has no knowledge that the transact partner has no authority. But if this happens, the partnership can recover the property if the conveyance is not the usual way of business or a fraud, or the conveyance is in the usual way of business, but the buyer has knowledge that the transact partner has no authority. On the third paragraph, the scenario is that the partnership is in the name of one or more of partners, and the conveyance is in the name of the partners in whose name appears on the title. The example of this is that there is a piece of land that really belongs to the partnership, but in the certificate of title, it is just a name of a certain partner is stated, and that certain partner sells that land even if it was belong to the partnership. Under the first paragraph of Article 1818, the conveyance passes the title. But, just like in the first scenario, the partnership can recover the property if the conveyance is not in the usual way of business or a fraud, or the conveyance is in the usual way of business, but the buyer has knowledge that the transact partner has no authority. And on the fourth paragraph, the scenario is that the partnership property is in the name of one or more partners or all of the partners, and the conveyance is in the name of the partnership or in the name of a partner. Then, the conveyance will not pass the title but only the equitable interest. And on the fifth and last paragraph, the scenario is that the partnership property is in the name of all the partners, and the conveyance is in the name of all partners. In this scenario, since all of the partners' name is in the title and all of them authorize the conveyance, then the conveyance will pass the title to the buyer. It will be noticed that under the paragraph 1, 3, and 5, what is conveyed is the title or the ownership, while under the paragraph 2 and 4, what is conveyed is merely equitable interest. Conveyance interpreted to include a mortgage. Thus, the right to mortgage is included in the right way to convey. And that would be all, and thank you.
This article states that an admission or representation of the partner is considered as inadmissible as long as it is concerning about partnership affairs, and this is must within the scope of his authority. Definitely, this is strong and sufficient evidence that can be used against the partnership. Example for this, let us say partner A's scope is in financial matter. He borrowed money from the bank and uses the name of the partnership. This affair committed by partner A is the sufficient evidence that can heavily used against the partnership. Once partner A can pay back his credit to the bank can pursue the partnership since partner A used the name of the partnership. Other example for this article. He admits anything concerning partnership affairs, but it is not part of his obligation, which distinct to the scope of his authority. So in this case, this evidence can't be used against the partnership. Let's proceed. Article 1821. This article talks regarding notice or knowledge. Basically, the knowledge of a partner consider the knowledge to the partnership. Example for this, A, B, and C are partners, where C partner is the managerial partner. The partners really wanted to buy a land, and D is the third person. The third person inform or give warn to partner B that the land is under litigation, where E can claim the land. In the end, na-claim jud ni A ang land. So, in this case, the partnership can't pursue the land anymore since the third person is already convey the information to partner B. Even partner B is non-managerial partner or acting partner. Si partner B is liable about the certain notice or knowledge by the third person because it is concerned the partnership.
Good day everyone. I'm Kenneth Cerezo. I'll be discussing Article 1822 and 1823 in Law of Partnership. Article 1822, whereby any wrongful act or omission of any partner is acting in the ordinary course of the business of the partnership or with the authority of his co-partners. loss or injury is caused to any person not being a partner in the partnership, or any penalty is incurred, the partnership is liable therefore to the same extent as the partner so acting or omitting to act. That wrongful act or omission that causes loss or injury to the third person. Why is it third person? It is stated here to any person not being a partner in the partnership. So it pertains to a third person causing injury or loss. Partner liable for the wrongful act of the partner. The partners are liable for the negligence operation of a vehicle by a partner acting in a course of business which result in a traffic accident. If he is driving a partnership-owned vehicle for the purpose of his own, the acting partner alone is liable. It is not a partnership tort. Partnership may proceed against negligent partner. Where a partnership is liable to a third person, there was a right of indemnity against the partner whose negligence caused the injuries. Article 1823. The partnership is bound to make good loss. There is two scopes under this article. Number 1, where one partner acting within the scope of his apparent authority receives money or property of a third person and misapplies it. Example, a partnership is engaged in a pawn shop business. D, a third person, pawned his watch to A and sells it. Who is liable for the watch? All partners are liable to D since A misapplies the watch received from D. Number 2, where the partnership is in the course of its business receives money or property of the third person and the money or property so received is misapplied by any partner while it is in the custody of the partnership. Example, A partner is engaged in a pawn shop business where it was received a watch from D to be pawned. The watch is placed to a partnership vault. B, a partner, gets the watch from the vault and sells it. Who is liable for the watch? All partners are solidarily liable. Article 1823 is all about misapplied of asset entrusted to the partner of or partnership. Misapplication of money or property in the third person shall be liable when it was received within the scope of authority or by any other partner after it was received by the partnership in ordinary course of business while in its custody. According to Article 1824, liabilities arising from partners' wrongful act or omission or breach of trust are liable solidarily, meaning each of the partner or the partnership itself is liable for the whole obligation. That's all for Article 1822 and 1823. Thank you.
Hey everyone! Today I will be discussing Article 1824 in the Law on Partnership and Corporation Law. Article 1824. All partners are liable solidarily with the partnership for everything chargeable to the partnership under Articles 1822 and 1823. Let me explain this one. The law imposes solidary liability upon the partners and the partnership in cases of torts and acts of conversion by a partner as provided in Article 1824. It may be stated that the liability of a partner for a debt of the partnership depends upon whether the debt is contractual or it arises from tort or conversion. If it arises from contract, the liability is subsidiary and pro rata. If it arises from tort or conversion, the liability is solidary. Let me give you a quick example. You and your friend borrows money from a lending company, and you sign as her co-maker. Now, your friend cannot pay the money she borrowed, As a co-maker, you are now responsible to pay in her behalf. Let's say she borrowed 1,000 pesos. Now, you need to pay the full 1,000 pesos as well because contractual is joint. Whether it's not your fault that your friend cannot pay, you as well is also liable. That is why it is called solidary liability. Now, let's proceed to business partner solidary liable. Article 1711 and 1712 of the law, New Civil Code, and Section 2 of the Workmen's Compensation Act reasonably indicate that the compensation cases, the liability of business partners should be merely joint and not solidary, and one of them happens to be insolvent. The amount awarded to the dependents of the deceased employee would only be partially satisfied, which is evidently contrary to the intent and purpose of the law to give full protection to the employee. Let me give you a quick example. Your sister works in land bank, and now she passes away. You, as a dependent of your sister, will receive money from the company. Instead of receiving 100,000, the company will only give you 50,000 and 50,000 from insurance benefits. This case is called joint liability. That would be all. Thank you.
Good day, everyone. I am Kinan Jairasi Katian of Group 4. Today, I'm going to discuss the Law of Partnership, Article 1825. When a person, by words spoken or written or by conduct, represents himself or consents to another representing him to anyone as a partner in an existing partnership or with one or more persons, not actual partners, he is liable to any such persons to whom such representation has been made, who has, on the faith of such representation, given credit to the actual or apparent partnership. And if he has made such representation or consented to its being made in a public manner, he is liable to such person, whether the representation has or has not been made or communicated to such person, so giving credit by or with the knowledge of the partner making the representation or consenting to its being made. When a partnership liability result, he is liable as though he were an actual member of the partnership. 2. When the partnership liability result, he is liable pro rata with other person, if any, so consenting to the contract or representation as to incur liability otherwise separately. When a person has been thus represented to be a partner in an existing partnership or with one or more persons not actual partners, he is an agent of the persons consenting to such representation to bind them to the same extent and in the same manner as though he were a partner in the fact with respect to persons who rely upon representation. When all the members of the existing partnership consent to the representation, a partnership act or obligation results. But in all other cases, it is the joint act or obligation of the person acting in the person consenting to the representation. Estoppel, a preclusion in law which prevents a man from alleging or denying a fact in consequence of his own previous act, allegation or denial of a contrary tenor. A person bound by his representation, a person who holds himself out as a partner in a business or consent to his being so held out, is liable on contracts made with third person who deal with a person carrying on the business on the faith of representation. He is stopped to deny the apparent agency. To get the meaning of Article 1825, for example, suppose there is a business meeting and you are not around, but you have to hire a person that representing as yourself. So whatever the meeting agrees and whatever that person says and he or she signated with a contract about that partnership or talking about a partnership, that is a fact with or without your approval, since he is your substitution or representing as yourself. So whatever the liability result of a partnership, he is liable as though he were an actual member of the partnership. Next, I'm going to give an example of staples. Number 1, partnership by staples. There is an existing partnership and partners represents themselves together with a third person. Example, suppose there is a partnership X with partners A, B, C, and D. A, B, and C. D told E that he is a partner of A, B, and C. E verified from the actual partners of X partnership. If D is really a partner, A, B, and C consented. E entered in a contract with D, believing he was a partner. This is partnership by staples since A, B, and C verified D as a partner. In this case, E can go after A, B, and C. Next, suppose only A and B consented. Is there a partnership by staples? There will be no partnership by staples since only A and B, not all partners, consented to this misrepresentation. So next, partners by staples. 2 or more persons pretend to be a partners in the eyes of third persons. Example, A, B, and C said they were partners to D and entered in a contract with the partners. When it was time for them to pay D for their obligation, they cannot for the reasons that they are not partners. What is their obligation to D? Their obligation to D will be pro rata, as if they were partners, since they are partners by staples. Thank you for listening to me about the Article 1825. I hope you get the meaning of Article 1825. Thank you.
So now let's move on to Article 1826. A person admitted as a partner into an existing partnership is liable for all the obligations of the partnership arising before his admission as though he had been a partner when such obligations were incurred, except that this liability shall be satisfied only out of partnership property unless there is a stipulation to the contrary.
In Article 1826, this means that someone who is accepted as a partner in a partnership type of business is also responsible with all the obligations of the partnership, but his liability will be based on the shares when it comes to the partnership property, and his own individual liability will not be included.
So let's have an example. A, B, and C are the original partners of the partnership X, with contributions of 10,000 pesos each. X partnership owes D 40,000 pesos. Later on, E entered the partnership and contributed 4,000 pesos. How shall the debt be paid?
To answer the given example, the 34,000 will be paid to D out of the partnership assets. The 6,000 will be paid through A, B, and C's personal assets, and the remaining 6K will be decided among the 3 original partners.
Next is the Article 1827. The creditors of the partnership shall be preferred to those of each partner as regards the partnership property. Without prejudice to this right, the private creditors of each partner may ask the attachment and public sale of the share of the latter in the partnership assets.
In this article, I understand that the partnership creditors have the better rights to the partner's obligation about the partnership property, and personal creditors of partners have the better rights than the partnership creditor when it comes to the personal property of the partner.
For example, A, B, C are partners. A owes E 6,000 pesos. The partnership owes D 28,000 pesos. The total partnership assets amount to 40,000 pesos. Who has the better right to the partnership property?
So in this case, D, which is the partnership creditor, has the better rights to the partnership property. When the obligation to D is paid, what will be left for the partners to share is only 4,000 pesos. Then, if E, the personal creditors of A, demands to paid out of partnership property, he will only get 4,000 pesos from it since the priority is of the partnership creditor. Then, the 2K will be paid out from A's personal asset.